Swayam Prabha. Digital India. Educated India.
Welcome to the course on Medical Law. This lecture deals with penalties for non-compliance. The concepts covered in this lecture are offences and penalties under the Surrogacy Regulation Act of 2021, offences and penalties under the Assisted Reproductive Technology Regulation Act 2021, offences and penalties under the Preconception and Prenatal Diagnostic Techniques Act of 1994. The keywords of this lecture are surrogacy, assisted reproductive technology, sex determination, preconception, prenatal diagnostic techniques, offences and penalties. The practices of surrogacy, assisted reproductive technology and preconception and prenatal diagnostic techniques are regulated under three separate legislations. These legislations create a coherent and effective legal framework to address the multifarious issues related to different medical practices. They also have adequate provisions to deal with non-compliance. In this context, it is pertinent to understand the consequence of non-compliance with the statutory provisions. In the previous lectures, we have covered in detail the provisions in the regulatory law for surrogacy, assisted reproductive technique and the preconception and prenatal diagnostic technique. In this lecture, we will be covering only the penalties for non-compliance with the regulatory provisions. In today's era, law tries to cope with the technology and also with dynamic changes happening in the society. Surrogacy regulation was enacted to regulate the process of surrogacy and also to protect vulnerable women from being exploited. The assisted reproductive technology regulation was introduced with the objective of regulating ART clinics and ART banks. The Preconception and Prenatal Diagnostic Techniques Regulation Act was introduced to prohibit sex selection and prevent female infanticide in the country. Now, let us start from the offences and penalties under the Surrogacy Act of 2021. Chapter 7 of the Surrogacy Regulation Act deals with offences and penalties. In this chapter, section 38 deals with prohibition of commercial surrogacy, exploitation of surrogate mothers and protection of children born through surrogacy. Under section 38 of the Act, no person, organization, surrogacy clinic, laboratory or clinical establishment shall 1. Undertake commercial surrogacy, 2. Provide components related to commercial surrogacy, 3. Provide services relating to commercial surrogacy and 4. Engage any intermediary or arrange surrogate mothers. So, section 38 of the Surrogacy Regulation Act prohibits any person, organization, surrogacy clinic, laboratory or a clinical establishment in getting involved in unethical practices in surrogacy. So, undertaking of commercial surrogacy or doing any act with regard to commercial surrogacy or engaging any intermediary to arrange surrogate mothers is prohibited under section 38 of the Surrogacy Regulation Act. Similarly, issuing or publishing or communicating or causing any advertisement regarding commercial surrogacy is prohibited. The abandoning or disowning the child born through surrogacy is also prohibited. Exploitation of surrogate mother or children born through surrogacy is also punishable under the Surrogacy Regulation Act. The clinics involved in surrogacy are prohibited from selling human embryo, gametes, or import any human embryo or gamete for surrogacy or similar procedure. There is also a complete ban on conducting of sex selection in any form during surrogacy. Under section 38, whoever contravenes with these provisions shall be punished with imprisonment for a term which extend to 10 years and with fine which extend to 10 lakh rupees. So, we have already discussed the prohibitions or regulations under the Surrogacy Regulation Act. Any person who contravenes with these regulatory requirements which are provided under section 38 will be punished with imprisonment for a term which may extend to 10 years and with fine which may extend to 10 lakh rupees. Extend to 10 years and with fine which may extend to 10 lakh rupees. So, any intending couple or intending woman or any person involved in surrogacy, if they does not follow altruistic surrogacy or conduct surrogacy for commercial purpose, they shall be punished with imprisonment up to 5 years and with fine up to 5 lakh rupees. But if they are committing a subsequent offence of the same nature, then the punishment will extend to 10 years of imprisonment and fine up to 10 lakh rupees. Section 42 of the Act provides the presumption of the offence. Under the legislation, that is the Surrogacy Regulation Act, there is a strong presumption in favor of the woman. Under the section, the court shall presume that woman or the surrogate mother was compelled by her husband or any other relative to render surrogacy service. In such case, the offender shall be liable for abetment of such offence and shall be punished as provided in section 40. Any offence under the Surrogacy Regulation Act is cognizable, non-bailable and non-compoundable. This is provided in section 43. Under section 45, provision relating to pre-bargaining, which is given in chapter 21A of the Code of Criminal Procedure, does not apply to the offences under the Surrogacy Act. In this context, it must be noted that Criminal Procedure Code of 1973 is going to be replaced with the new legislation, which is the Bharatiya Nagarik Suraksha Sanhita of 2023. The chapter 23 of the new legislation deals with plea bargaining. So, under section 45 of the Surrogacy Regulation Act, plea bargaining provision will not apply to offences under the Surrogacy Regulation Act. Now, let us discuss the offences and penalties under the Assisted Reproductive Technology Regulation Act of 2021. Chapter 5 of the Assisted Reproductive Technology Regulation Act deals with the offences and penalties. In Chapter 5, sections 32 to 37 deals with offences and penalties. This chapter deals with different offences like sex selective assisted reproductive technology advertisement, exploitation, selling of embryos, etc. So, under this chapter, conducting of sex selection, doing an advertisement with regard to sex selection, exploitation, selling of embryos are all considered as punishable offences. Section 32 of the Act deals with advertisement issued regarding facilities of sex selective assisted reproductive technology. Any clinic, bank or agent which advertises sex selective assisted reproductive technology commits an offence under this Act. The punishment of this offence shall be imprisonment for a period not less than 5 years and which may extend to 10 years, and with fine which shall not be less than 10 lakh rupees, but may extend to 25 lakh rupees. So, as you can see, the punishment provided under the ART Act is very stringent in nature. Section 33 of the Assisted Reproductive Technology Act provides that any medical geneticist, gynecologist or registered medical practitioner shall not abandon, disown or exploit a child born through assisted reproductive technology. Second, sell human embryos or gametes. Third, import human embryos or human gametes. Fourth, exploit the commissioning couple, woman or gamete donor. Fifth, transfer human embryos into a male person or an animal. 5. Engage any intermediaries to obtain gamete donors or purchase gamete donors. So, section 33 of the Act imposes certain prohibitions on practitioners involved in assisted reproductive technology. Whoever contravenes this provision will be punishable with fine which shall not be less than 5 lakh rupees and which can extend up to 10 lakh rupees. In case of a subsequent offence, imprisonment for a term of 3 years and which may extend to 8 years and with fine not less than 10 lakh rupees and which can extend to 20 lakh rupees is provided under section 33 of the ART Act. Cognizance of offences under section 35 shall not be taken by any court inferior to metropolitan magistrate or judicial magistrate of first class unless a complaint is given by national board or the state board. So, under the Act, the court can take the cognizance only when there is a complaint given by the national board or the state board. Offences provided under the Act are cognizable and bailable. This is provided in section 36 of the Act. Offences and penalties under Preconception and Prenatal Diagnostic Techniques Act 1994 can be discussed. Chapter 7 deals with the offences and penalties under this legislation. Section 22 to 28 is covered in Chapter 7. Chapter 7 provides the penalties for advertisement, offences by medical professionals and offences by companies. Section 22 of the Act deals with prohibition of advertisement relating to preconception and prenatal determination of sex. Any person who contravenes the provision shall be punished with imprisonment for a term which may extend to 3 years and with fine which may extend to 10,000 rupees. So, under this legislation, there is complete prohibition on preconception and prenatal determination of sex. Any person who contravenes this provision will be punished with an imprisonment which may extend to 3 years and with fine which can extend to 10,000 rupees. Section 23 of the Act states that if any professional who is involved in medical practice contravenes the provisions of the legislation, he shall be punished with imprisonment for a term which can extend to 3 years, and with fine which can extend to 10,000 rupees for the first offence. For any subsequent offence, the punishment shall extend to 5 years and fine up to 50,000 rupees. And if it is a medical practitioner who has committed the offence, the state medical council concerned shall suspend the registration if the charges is framed by the court, and if the person is convicted, his name shall be removed from the register for a period of 5 years for the first offence. In case of any subsequent offence, the name shall be removed permanently from the register of the state medical council. If a person performs prenatal diagnostic technique for a purpose other than which is permitted under the legislation, he shall be punished with an imprisonment up to 3 years and with fine up to 50,000 rupees for the first offence. In case of a subsequent offence, he shall be punished with an imprisonment up to 5 years and with fine up to 1 lakh rupees. The legislation specifically provides the scenarios under which prenatal diagnostic technique could be used. So, if a medical practitioner performs the prenatal diagnostic technique other than for a purpose which is allowed under the Act, it constitutes a punishable offence. So, in case of the first offence, he shall be punished with an imprisonment up to 3 years and fine up to 50,000 rupees. In case of a subsequent offence, the punishment extends to imprisonment for a term of 5 years and fine up to 1 lakh rupees. Every offence under this legislation shall be cognizable, non-bailable and non-computable. This is provided in section 27 of the Preconception and Prenatal Diagnostic Techniques Regulation Act. Under section 28 of the Act, cognizance of the offence shall be taken only if a complaint is filed by either the appropriate authority or a person who has given 15 days notice of an alleged offence to the appropriate authority. So, under this Act, cognizance can be taken only on the basis of a complaint. The complaint can be either from the appropriate authority constituted under the legislation or from any person who has given a notice of not less than 15 days to the appropriate authority. The cognizance of the offence shall not be taken by any court inferior to the metropolitan magistrate or a judicial magistrate of first class. To conclude, this legal framework aimed to strike a balance between the need to encourage advanced medical treatment and the protection of ethical principles, thereby ensuring the well-being of patients. The Surrogacy Act, with its stringent provisions against commercial surrogacy, aims to eliminate the potential exploitation of surrogate mothers and commodification of surrogacy process. Similarly, the Assisted Reproductive Technology Regulation Act provides comprehensive regulatory framework for assisted reproductive technologies. The Preconception and Prenatal Diagnostic Techniques Regulation Act stands as a crucial legislative tool in India's commitment towards eradicating sex selective practices and upholds the principles of gender equality. Its stringent provisions and penalties underscore the need to protect the rights of girl child and create a societal environment that values the lives of all human beings. The references of this lecture can be seen here. Thank you very much for listening to this lecture. I hope you are enjoying the course.